Manoj, on perusal of the clauses, it is clear that in case of misleading or false representation, I have the power to disqualify. Where the undertaking given is violated, I have the power to forfeit the EMD as well as blacklist. And under clause 21.6.
Just a minute.
Lordship.
Yes.
Manoj. Manoj, on the first page, clause 1.113, the bidder will be disqualified for misleading and false representation. Below that, the bidder should submit an undertaking. The board shall have a right to forfeit the EMD and blacklist if the information is found to be faulty, incorrect, or misleading. On the second page, my lords, bid security may be forfeited if the documents submitted by the bidder are false and fraudulent. In case of forfeiture of EMD, bidder shall be disqualified and not allowed to bid for a period of 3 years. My lords, at D, clause 24.7 is with regard to a joint venture cannot use the documents of individual applicant. My lords, thereafter, for evaluation of bids, again would be disqualified if misleading or false representation made. Below that, once again, my lords, the clause for undertaking.
But do you have a clause which is exactly reverse to 24.7?
My lords, my lords, that is on the next page. Reverse to 24, my lords, yes. On page C, my lords have G, page 85 of the petition, minimum qualifying criteria. To qualify, each bidder in the same name and style should have achieved the following performances. And thereafter 4.1 and 4.1.5, where one contract of so and so, two contracts, three contracts. Therefore, my lords, in case of misleading information, false representation, fraud, as well as fraud, I have the power to forfeit the EMD as well as blacklist the bidder. Now, my lords, to begin with, there are three contentions which are raised by my learned senior. The first is that the document is genuine as held by the government company issuing it. The second, that prior to forfeiting the EMD, no show cause notice was given. And third, that the show cause notice of blacklisting is not proper. It does not state the punishment to be given. My lords, to begin with, I may first take my lords to their admission at page 10 of the petition. It starts at page 9.
You once again repeat that last contention which you are answering.
The last contention was that the show cause notice is not proper as it does not state the punishment to be imposed upon the bidder, upon the petitioner.
Okay.
They have also stated that no personal hearing was given. I will address that as well.
Yes, please.
My lords, page 9 of the petition starts from C. That a conjoint reading of the aforesaid tender terms and conditions establishes that the bidder has the power to disqualify a bidder if the bidder submits misleading or false attachment in proof of qualification requirement. In the present case, the respondent has used this clause to disqualify the petitioner from the tender in question, against which the petitioner does not have any grievance. So the petitioner has accepted its disqualification. The petitioner has accepted the wrongdoing. Now, my lords, it is clear that the first certificate merely mentions the name of the petitioner. My lords, page 195 may be seen, the letter by the company issuing the certificate. 195. That is the letter of the Gujarat Urban Development Company to whom we had written for verification. Our letter seeking verification is at page 192, And the response is at page.
In your way, which is that same page?
Oh, Lordships.
In there,
Page 141. Page 141.
140. I'll read from 141, my lords. With reference to the subject cited above and above report letter regarding verification of 3A certificate issued by Gujarat Construction Company Mehsana, it is to inform that the 3A certificate which is in question to verify at our end is genuine and issued by this company. Copy issued form 3A certificate is attached herewith. Now, as per contractor's request, my lords, this is relevant. As per contractor's request for